Troika is a brand consulting, creative design, and content group that holds the view that brands are a company's most valuable asset and that the most enduring brands forge strong emotional bonds with audiences and supporters. To assist brands in converting audiences into ardent fans, they adopt a fan-centric perspective that guides the way they think, create, and design. Their craft is a blend of art and strategic thinking to create a holistic and meaningful brand experience that builds highly engaged, loyal audiences. Using immersive live experiences, brand partnerships, PR, social media, and influencer marketing, Mission is a communications company that helps brands stand out by interacting with consumers from a cultural perspective.
You are watching America Trends. I'm Mary Burke Godwin, and I have a new guest that we haven't had on the show before. I'm so excited to interview Annie Ellis, employment lawyer. Welcome to America Trends.
Thanks, Mary.
I think you've been here. Have you been on Big Biz Show before?
I have.
Yes. Okay, good. So you're not new to Loft 100 Studios, just to our show.
This room I'm new to.
This studio, yes. Well, AnnieEllisLaw.com is your website, right?
Yes.
And you specialize in employment law.
I do.
So let's dive right into the hot topic. You were saying this is the #1 topic that all business owners want to talk about is arbitration agreements.
Really exciting stuff.
It's exciting. I can't wait to talk about it because there's a lot I don't know and understand. So I really want, because that is something that really all employers should have in place, right?
Right, and let's start with what's arbitration, because I hear arbitration and mediation used interchangeably, which they're not. Arbitration is private court. So
Okay.
employers give a document to their employees and say...
Is that like people's court, or Judge Judy?
A little more private than that.
Okay.
Few more rules.
Okay.
But to the extent that employers want to say you're not waiving any rights, you're not saying you can't sue your employer for anything, but if you are going to do it, then you're going to do it on an individual basis, not banding together with other employees, and you're going to do it privately with a company that does arbitration, not in public superior big kid court.
Wow. So as a business owner, you could have something like that in place that when you hire someone new, they would sign that. It's almost a little bit like a prenup kind of for a marriage. I don't know why that's making me think of that, but you would want to say, hey, if something goes sideways with our relationship, a business employer employee, you're not going to band together and get all the people on your side and take this to a major court. We're going to do it on the side.
Right, and during the Me Too movement, there was a lot of hostility toward arbitration, and I want to clarify that most employers, particularly ones in California, they want arbitration not because they're trying to hide sexual harassment lawsuits. They're doing it for the wage and hour benefits because, like I mentioned earlier, you can't band together, and that's when wage and hour, these labor code violations become bet the company type litigation, and if you're a business owner, this can put you under. And federal law changed a few months ago, so we can't even include sexual harassment in arbitration anyway. It's everything but.
Oh, that's interesting.
It is interesting.
Okay.
And so,
And how come? Because they want to make sure that people aren't hiding and sweeping stuff under the rug.
Right, and remember a few months ago there was the testimony from a lot of the Olympic gymnasts that said, here's what happened, you guys swept it under the rug, obviously with Ashley Judd and her case, and so they want to make sure that business owners and wrongdoers are held accountable in a public forum, and I'm all in favor of that.
Yes.
It is the bet the company litigation on these hyper-technical wage and hour violations where you might have missed something by 30 seconds that I feel needs to be changed in California.
Okay, so is it just California that the sexual harassment is not included, or it's
everywhere? That's a federal law.
Federal law. And is that the Viking River case, or what's the Viking River case?
Viking River case is specific to California. It did come out of the U.S. Supreme Court. We don't often listen to what the U.S. Supreme Court does because our laws are much more difficult than the federal ones. But what that says is we can now have a waiver of all wage and hour type violations where employees can't band together. So if I'm disgruntled and I maybe missed a couple breaks or didn't get paid a couple of hours of overtime, that's a very small case for a plaintiff's attorney to take, for an employer to settle out. So what they do is they get together and they say, we're going to drag everyone into this case, all 500 employees. The Viking River case says employers can now include language in their arbitration agreements preventing that.
Okay.
That's big deal. That is game changing.
And that is happening now, or has that been settled?
That decision came out on June 15th.
Okay.
And what's interesting is that when you look at the notices for new filings in California for the types of cases that this decision was designed to prevent, There was 300 new cases filed in the first 3 weeks in July. That was like a 300% increase from what we'd seen in the past. And here's why. Because plaintiffs' attorneys are trying to get their cases in before employers get around to changing their agreements to have this type of waiver in there.
Everyone wants to hustle and get it in there.
So get in there, get your documents changed, get it updated. If you are a business owner, if you've invested in a business, this is what is going to save you.
You can change your language.
Hundreds
right
of thousands of dollars, if not millions of dollars. This is what's going to save you.
Wow. Okay, that is really big. And can you explain to me, you said there's a difference between arbitration and mediation. Can you break that down a little bit?
Yeah, arbitration is where you file a claim and you litigate it and do discovery and go to a hearing or a trial before, you know, a neutral person that functions as a judge. Mediation is private, confidential, where you go to settle something. So it's, I've got my claims, but
It's a little boardroom.
Right.
And it's just maybe one attorney?
One attorney for each side, and then a neutral mediator to go back and forth, shuttle between the two, and try to come to some sort of settlement agreement by the end of the day.
Okay, got it. But so the arbitration agreements, and so this is something that our business owners should really be hiring someone like you to help. Hopefully they already have a lawyer that they work with on all their documents.
I tell my clients, if it's my business and I own it, which I do own my own business, I'm putting arbitration agreements in every day of the week and twice on Sunday. Don't hesitate.
Okay, and that's something that they sign when they first sign to hire, right?
Ideally, you don't have to. You can do it mid-employment, but a best case scenario would be, here's your offer, and if you want to accept it, you got to sign this other document too.
Okay, got it. That's really important stuff. And people, because people who watch the show are from all over the country, so each state is a little different, is that correct?
Each state is different, but I would recommend this in any state no matter what, because you can have that company-wide type litigation that I mentioned under federal law as well and under states. Now, it just so happens that our laws are more rigid, so it's more expensive here, but that doesn't mean you can't benefit from it no matter where you are.
Okay, great tip. Now I want to talk about, there's a pending bill here in California that prohibits discrimination against marijuana using employees. Now, marijuana is legal now in our state. I don't think it's legal in all states across the country, but so what's this law? Can an employer fire somebody right now for being high?
Yeah, and common misconception, because legally it is okay to have recreational and medicinal marijuana in California and has been for years. But let's go back to that new hire example I just said. Offer of employment, and you got to take a drug test. If that employee takes a drug test and turns up positive for THC, the employer can choose not to hire that person. Or if you show up high under the influence to work, you can fire them as well.
See, now that I could understand, because you don't want them high at your business. I mean, they can do whatever they want at home.
Right.
I guess, but if it's legal. But then if they're showing up to the place of employment, I can see where an employer would say,
and that's
maybe you need to be
probably not
sober.
going to change. So that part of being under the influence, I mean, that's not unique to marijuana or alcohol or any other prescription drugs that someone might be overusing.
Right.
So that's going to remain intact. But the making employees pass a THC drug test as a condition of employment, that's what they're hoping to change. And I fully support that. I mean, this is 2022. Come on, guys. Let's get real.
Let's get real. Yeah, absolutely. I mean, we know that people are doing it, and it's been made legal, so let them have their own.
I always tell.
I guess it would be hard to know when you do the test, if it's been in your bloodstream from last night or from this morning.
And that's what I tell employers. I say, don't test for it. Just take it out of the screening panel, because your applicant pool in a labor market like it is right now, you're just going to diminish it. And why? Because someone has a medical marijuana card that they might use twice a month and it showed up positive.
Right.
Big whoop.
I mean, I guess there's other ways to know if they're going to be an issue than if they just don't pass if they have some THC in their blood.
Yes.
You know what I mean? So I want to talk about, earlier in the show we had a guest on talking about fentanyl and alcohol abuse and drug abuse, which is certainly a big issue. And, as an employer, what can you do if you suspect an employee of being under the influence at work? And not just THC,
It's going to vary a little bit state by state, but big picture umbrella, this rule will apply no matter where you are. So if you have reasonable suspicion that someone is under the influence, and you got to hit factors. So red eyes, slurring speech, can't walk. I mean, we all know what they are, right? Yeah. And you have 2 or more managers that can attest to that, then you go and send them to get tested on the spot. And if they refuse to get tested, then that's deemed a positive result and you can terminate their employment. employment. So that's immediately.
Okay.
And what's interesting, and I have a lot of employers that I work with that struggle with this, is okay, I have a restaurant at 7 p.m. on a Saturday night. Where am I going to send them to get drug tested? So I always recommend having breathalyzers on hand. You can order them off Amazon, and then seeing if you can get like home drug tests in order to keep in the restaurant, because otherwise you're just kind of stuck.
Right. Well, and actually, I want to talk more about this, because also, what can employers do to maybe help if they don't want to fire this person, because they might be a really great employee and they just might need to get help. So we got to take a break, though. We stick around for another segment, because I want to talk about how employers can actually help their employees, since this is such an epidemic. Everyone at home, stick around. We've got more with Annie Ellis, AnnieEllisLaw.com. So much great tips coming from you. If you are a business owner, you're going to want to stick around and hear this. And you can also find us on social media at America Trends TV, Facebook, Instagram, and Twitter. And we will be right back right after this.